Okay, so in this lecture we're going over the Bill of Rights. So you should have handy your Constitution, and at various points we're going to read a section, so while you're reading you can pause the video. And then you should also have printed up the notes, all right, and you can take more notes on the side as we go. So we were covering the Bill of Rights. To start off, though, I want to make sure we know the difference between civil rights and civil liberties. Because they both sound good, they both sound important, but often there's confusion about the difference between the two. So civil liberties is primarily what the Bill of Rights is focused on. Civil liberties is about protecting your freedoms, hence liberty, but we often refer to civil liberties as rights. So a civil liberty is the idea that you should be protected from the government. And if we think about John Locke's ideas about liberty, you get your liberty by limiting the government. So the Bill of Rights limits the federal government, thereby making you more free. And we already covered the First Amendment, and we'll go over it again today. But you'll see the wording in the Bill of Rights is not so much that you have a right to things, but rather because the government is limited in some way, that secures that freedom. Civil rights, on the other hand, is actually often involving the government in order to protect your rights. So an example of a civil right is your right to not be discriminated against in the workplace and your right to vote. So civil rights often involves a positive act of the government to protect your right to do something in some way. And a civil liberty is actually about government stay out, so I have freedom of speech without fear of imprisonment. Okay, so the Bill of Rights primarily focuses on civil liberties. And when we think about the Bill of Rights, we have to remember it's technically not part of the original Constitution. It's the 10 Amendments added very shortly thereafter as a compromise between the Federalists and the Anti-Federalists. And which group wanted the Bill of Rights? That would be the Anti-Federalists. They were concerned about a federal government that was too powerful and would then, infringe the basic liberties that the government is supposed to protect. So the Bill of Rights was added. It's the first 10 amendments. And it doesn't say so much that this is your right or your freedom, but rather is going to say what the government cannot do. And the Bill of Rights limits which government. In this case, it would be the federal government. So if I can get you to read the First Amendment, pause this, and we're going to go to the First Amendment, but I do need you to have recently read and seen the exact wording of the First Amendment. Okay, so you'll notice in the First Amendment it says Congress shall make no law respecting the establishment of religion. That's the Establishment Clause. And the wording is not, you're not the subject. People are not the subject. The subject here is Congress. And it's a restriction on what kind of law Congress could make. I like to think of the Establishment Clause as your freedom from religion. The government cannot impose a religion upon you. And then right after the Establishment Clause, you have the Free Exercise Clause. In a nutshell, I would say that's your freedom of religion. So when we say religious freedom, it's a two-parter. You have the freedom to believe what you want, and you also have the freedom from a government that would impose any sort of religion upon you. The Lemon Test refers to Lemon v. Kurtzman, a case the Supreme Court took with regards to the Establishment Clause, but it's been used since as a way for the Supreme Court to try and be consistent in the way that they settle these disputes, and they are rather tricky to settle. And then the First Amendment goes on to give you other freedoms, particularly freedom of speech, freedom of the press, freedom to assemble, freedom to petition the government, and then you kind of combine all those into the idea of freedom of expression. And that idea that there's expression, that's not necessarily, spoken words, comes from Texas v. Johnson. That was a 1980s case in which Johnson burned the American flag at the Republican National Convention in Texas. And he was convicted. There was a law in Texas, as there was in many other states, that you cannot burn the American flag. And he did. And he was charged and convicted and imprisoned. And he appealed the case, not on the grounds that he didn't do it. He definitely did it. Everyone saw. But on the grounds that Texas's law was unconstitutional. In the Supreme Court ruling, the majority opinion sided with Johnson, thereby telling all the states in the Union that you cannot have laws on the books that would ban someone from burning the American flag. Tinker v. Des Moines is a similar case having to do with freedom of expression. In this case, the Tinker family, a pacifist family against the Vietnam War, their child with a friend went to school wearing one of those black armbands to protest the Vietnam War. And the school administration suspended them and sent them home. They sued the school district on the grounds that that's freedom of expression. And here in this case, freedom of expression was upheld. The Supreme Court also sided with the Tinker family. So there are some cases where the Supreme Court weighs in on the interpretation of the First Amendment, siding with the protection of your freedom of expression and your religious freedom. Then there are limits on free speech. You may not just say whatever you want without consequence. If what you say, written or verbal, is detrimental to somebody else, that it costs them, they might sue you for libel. That's the written word that is false or malicious, and slander would be the spoken word that is false or malicious. So in a civil court, you could be sued if your speech affects someone in a negative way that they could claim damages or money. Also, you cannot speak out. You can criticize the government, but threatening the government, like overthrowing the government, that sort of treason, that would be considered sedition, seditious speech, and that also can be limited. Obscenity is a tricky one. What makes something obscene is often up to one's interpretation. The Supreme Court has tried to sort of define obscenity so that going out when they get a case regarding obscenity, they can clearly say this is obscene, this is not. But the court has allowed for your freedom of speech to be limited if they deem it obscene. And it comes from the Miller v. California case. The Miller test helps to define obscenity. In a sense, obscenity is according to this test, what is offensive to most, and lacks scientific, artistic, political, or literary meaning or relevance. And then you have, if you are presenting a threat to people or to the government, that there's a clear and present danger. This that comes out of the Schenck v. U.S. case of 1919. So that was kind of the First Amendment recap. We talk about the First Amendment at length another lesson, but a recap there. The Second Amendment I'll be kind of going right over, probably the most controversial one there, and where the controversy is around this very short amendment really has to do with keep and bear and what that means. Keep and bear versus, say, open and carry. You'll never see this this topic on the AP test because it is so controversial. So I'd like you to read over the Third Amendment, so pause now and read that. The Third Amendment is about quartering. But what is it saying about quartering? It is limiting the government's ability to quarter. When we say quarter, that means house soldiers. And this amendment is a reflection of the time that the colonists had felt that the British had abused their power by quartering soldiers in the colonists' homes. So can the U.S. government quarter soldiers in your home? Yes. If you read the amendment carefully, you will see, yes, they can be quartered, but not in times of peace, nor without a clear set of laws guiding the process. So quartering, it's a bit outdated. We haven't had a war on American soil in a long time, but it is left open that the U.S. government can quarter soldiers. It's limited here, and that protects your freedom in your home, your maybe a kind of an idea of privacy, or your property here. All right, read the fourth, pause this, and then we'll go over it. Okay, so the Fourth Amendment tackles searches and warrants. This is going to be very important for defendants' rights. It says that in order to search you or your property, law enforcement needs a warrant. But to get a warrant, they don't just write it up themselves. They have to go over to a court and get a judge to approve the warrant. So they have to show probable cause to the judge to get the warrant to go search you or your property. So we see here that this is some good checks and balances, where the executive branch is sort of limited by the judicial branch at this local level. And the idea is that we don't want our law enforcement harassing people. We do not want the police to abuse their power. Now, in the case of Mapp v. Ohio, you're going to write this even though we haven't got to incorporation yet. In the case of Mapp v. Ohio, a couple precedents come out of it. So Wright incorporates the fourth, or that's where we're at. We will cover that very soon. In this case, it establishes the exclusionary rule. The purpose of the exclusionary rule is to deter police misconduct and protect defendants' rights. So here's what the exclusionary rule is. It is the idea that if police obtain evidence illegally, meaning that they didn't follow due process, if they obtain their evidence illegally that they want to then use against the defendant, that evidence should be excluded from a court of law because the police didn't get it fair and square. So this is really critical to make sure that law enforcement is following following the rules and respecting Fourth Amendment rights and not harassing individuals. The exclusionary rule can be particularly frustrating when it comes to victims' rights, that just because a police officer found the evidence illegally doesn't mean it isn't evidence. There are some exceptions to the exclusionary rule. For example, if the prosecution can show that the evidence would have been found later anyways, that's inevitable discovery, then they can ask the judge if that evidence could be used. And then also if the officer can prove that they were acting in good faith, that they thought they were in accordance of the law in their actions of getting that evidence. So we'll come back to incorporates, but Mapp v. Ohio in 1961 establishes the exclusionary rule, and a very important part is that it incorporates the fourth. All right, the Fifth Amendment, I would say, is the one that lacks a clear singular theme. It's hard to come up with a title for the Fifth Amendment, and it covers a bunch of topics. So, firstly, we have the grand jury. The grand jury does not decide guilty or not guilty. In fact, they don't watch the trial happen at all. The grand jury is brought in for capital crimes and other large crimes before the trial, to even see if somebody should be indicted, if anyone should be charged with the crime. So the grand jury is about 16 to 25 people, and at this point what they're shown is the evidence thus far. The prosecution will say, here's all the evidence that our law enforcement has found, and we think based on this evidence that we should charge this person with the crime, essentially put them on trial. And that's a weighty power, and the Fifth Amendment is here to make sure that law enforcement and the state, or the federal government, are not out to harass anybody, and not out to, really being good with their resources. Because once somebody is charged, if they're found not guilty, the government at that point is not going out and looking for the real criminal. So when the state or government decides who to charge with the crime, who to put on trial, they're really putting all their eggs in one basket. So it better be a pretty good basket, so to speak. The grand jury does not have to be unanimous. So they'll look at the evidence and they'll decide, you know what, you actually do have enough evidence to charge this person with a crime. Or they'll say there's just not enough, and you'll need to find another suspect or move on. Another aspect of the Fifth Amendment, very important, is that there should not be double jeopardy. If the government has a trial and the jury says you're not guilty, they can't say, okay, well, let's do this again. What can get confusing is you might find yourself in a court of law multiple times for the same action. You can, in one action, be breaking a law and also doing wrong to another person and find yourself in criminal and then civil court with regards to that matter. The most famous part of the Fifth Amendment is your right to not testify against yourself, to plead the fifth. That is so that you cannot perjure yourself, but also not incriminate yourself. And the two most important clauses of the Fifth Amendment that we come back to really have to do with property. The Fifth Amendment says you cannot be deprived of life, liberty, or property without due process of law. Can you be deprived of life? Can the government take your life? Absolutely. Can the government take your liberty? Absolutely. We have a large prison population, and we absolutely do have capital punishment. Can the government take your property? Absolutely. In all three of those cases, as long as the government's following the rules, which is what due process is, then the government can take all three of those things, and those words made famous by John Locke. And the government takes your property usually through fines. So if you've had a traffic violation and you've paid